In this section, we will discuss voting and authority issues in the limited liability company. Most LLC statutes are heavily influenced by partnership law. This means that voting and authority in limited liability companies is very similar to voting and authority in partnerships. What does that mean specifically? Well, it means that each member of the limited liability company will have equal rights to participate in the management and business of the limited liability company. Now, this depends on jurisdictions, and we'll discuss that in a little bit more detail in the next section. So, what are we going to discuss? Well, we'll discuss voting on LLC decisions, and we'll discuss the authority of the members of the LLC to bind the LLC in contract. There is an exception, and we'll also talk about the exception. Remember, in some jurisdictions, you can elect to have a manager-managed LLC. That's centralized management in the limited liability company. You can have one manager, or you can have several managers. It could look very much like a board of directors if you wanted. If your jurisdiction allows you to have a manager-managed LLC, and you elect to have a manager-managed LLC, then voting and authority issues in the limited liability company are a little bit different, but not very difficult to understand. Let's talk briefly about voting rights in the limited liability company, and in the next section we'll discuss it in more detail. Remember, equal voting rights without regard to capital contribution. Very similar to the partnership. So each member gets one vote on partnership matters without regard to how much capital that member has contributed to the limited liability company. Once again, some jurisdictions provide for voting in proportion to capital contributions. So keep that in mind. You have to read your statute carefully. Just like in the partnership, there are usually no formal meeting requirements, no formal voting mechanisms required. Voting on ordinary matters, extraordinary matters, amendment to the operating agreement, and admission of a new member. If we are voting, if we're members in an LLC and we're voting on some sort of ordinary matter, the proposal requires approval of a majority of the members. If we are voting on an extraordinary matter, approval of this matter requires consent of all the members. If we are voting on amendment of the operating agreement, this requires approval of all the members, and similarly in most jurisdictions, admission of a new member requires approval of all members. Once again, similar to the partnership context, these are default rules which we can change in our operating agreement if we so choose. Let's talk about authority in limited liability companies. Same general principles that we have discussed with respect to agency authority for any type of agent-principal relationship, and very, very similar to what we discussed with respect to the agency authority of partners. Members in an LLC can have express authority, implied authority, or apparent authority. Remember what express authority means. Did the other members expressly vote to give our member authority to bind the LLC in this particular transaction? Implied authority, did the member reasonably believe that she had the authority to bind the LLC in this particular transaction? And apparent authority is, did the third party reasonably believe, based on the actions of the limited liability company, that the member had the authority to bind the LLC in this transaction? Now, remember in the partnership context, we said that a partner had the apparent authority to bind the partnership in ordinary business transactions simply by virtue of being a partner. In some jurisdictions, the rule for limited liability companies is the same. Once again, you have to read your statute pretty carefully. So, your member status, just the fact that you are a member, gives you the apparent authority to bind the limited liability company simply because you are a member, right? And once again, we're talking about ordinary business transactions. There is an exception. The exception is the manager-managed LLC. When we have a manager-managed LLC, the authority to bind the limited liability company is with the managers, not the members. And so we'd ask the same questions that we asked about the members with respect to express authority, implied authority, and apparent authority. Instead of asking about whether the member had the authority, we'd ask this about the managers. Let's talk quickly about voting in the limited liability company and the LLC Operating Agreement. If you remember, the operating agreement of the limited liability company is analogous to the corporation's articles of incorporation, its bylaws, its shareholders agreement, all rolled into one. So the operating agreement for the LLC is a very important document. Indeed, in many jurisdictions, if there's a conflict between the operating agreement of the limited liability company and the articles of organization of the limited liability company, the operating agreement will control. That's in sharp contrast to the corporation. In the corporate context, if the corporation's articles of incorporation conflict with the shareholders agreement or the bylaws, the articles of incorporation are going to control. In the corporate context, the articles of incorporation are the constitution of the corporation. In contrast, in the limited liability company, the operating agreement is the constitution of the company. In most jurisdictions, the LLC statutes are silent or give very little guidance on voting mechanisms and formalities. If you are a 1 or 2 member LLC, this is a good thing because you don't need a lot of voting mechanisms or formalities to run your LLC and run your business. Indeed, a lot of voting mechanisms and formalities could get in the way of your ability to run your business efficiently. However, as soon as you have quite a few members in your LLC, you're going to need voting formalities and mechanisms. Once again, the default rules in your LLC statute might say nothing about this. Therefore, your operating agreement should have these voting mechanisms and formalities. What type of voting mechanisms and formalities might you draft in your operating agreement? Well, that depends on the size of your LLC, how many members you have, etc. But you will borrow from the corporation. You'll borrow from corporate law, and you'll put those types of voting mechanisms and formalities in your operating agreement if you so choose.